Good morning, everybody. I know that's how you prefer that I look, but age has gotten the better of me. So we're going to have to take down the baby brother Counsel and come back with the real brother Counsel right here. The older version. Okay, not as cute, but what can you do? So we got Donna Adelson's pretrial today. We've got the trial coming up really soon, actually. So August 19th is when they're supposed to start. So that's when jury selection is supposed to begin anyway. So this may be the final pretrial. This actually may be the final pretrial. So there are a few motions up. One of the motions we actually went through. Some of you may have seen that already. And one of the motions has to do with her trip to Vietnam. We all remember that trip to Vietnam, that she tried to get her one-way ticket to Vietnam because she wanted to go on vacation. Just so happens to be she wanted to go on vacation right after Charlie was convicted. So, not a can't hold it against her, right? So the idea was, and that's what we're gonna use the Law and Crime Network stream. Hopefully, that should go. We'll take it down till they get started. It was either that or Court TV, I think. So, but anyway, so she filed this motion in limine that the prosecution should not be able to use that fact that she went to the Vietnam or tried to go to Vietnam as consciousness of guilt. After all, she booked that ticket before there were any charges against her, before there was an even arrest warrant. So how can you really argue that that is consciousness of guilt? So we went through that, and we showed how that argument does not hold any water. So they're going to argue it anyway. You got to try something, whatever works. So I'm going to try to argue it, and it's going to get denied. What can I tell you? But there's some other motions also that are up. So they'll argue some of that. Maybe we'll hear some more about the trial coming up. Maybe other issues came up. You never know. Just like last time when they were about to start the trial. All of a sudden, no trial. So anything can happen in court. Anything can happen in trial. So we'll see what happens. So while we're waiting for the stream to start, and again, there's nothing really going on there. I'll check Court TV just to make sure we're not missing anything, but I'm assuming Law and Crime is not going to miss it. Be sure. I'll look for Court TV also. And the sad thing is that there's no fan to watch while. So all you got is the seal of the state of Florida, which is what Court TV is showing right now. Oh. But if you want to see that, I can put that on. It's not terribly exciting. All right. Anyway, let's say hello to some people because you guys all joined me, and we're gonna get ready. We really have to get a little bit more psyched up for the Donna Adelson trial. I mean, come on. I know everyone was like on this letdown after Karen Reed. We had a great time together watching that trial, but there's going to be other trials. So now we have Donna Adelson coming up, and we got to get psyched up for this. Okay, we got to get hyped up. We got to get going. We got to get our Florida juice pumping. So we're going to take a trip south from Boston, and it's going to be an interesting trial. Should be a week, maybe 2-week trial. And definitely, if you've been following the entire saga, so this is the next step in the trial. Also, by the way, before I say hello to some people, even though I probably should, there was some discussion about whether there was an offer on the table for time served if she would give up Wendy. They spoke about that. There was somebody on. Hold on a second. Oh, here we go. There was someone on Surviving the Survivor thing. They had Tim Jansen. I've been on with him before. So he claimed that there was he had some information that there was an offer if she would give up Wendy, if she would testify against Wendy, that she can just go home basically and be done with it. That's what she claimed. That's what Tim Jansen claimed. But the defense team claims that that was not true, actually. And quite frankly, I would find it hard to believe. I would find that offer hard to believe. So I'm not even sure that happened. The defense claims it never happened. And yeah. But I think everybody wants to see Wendy get indicted. And remember, she does have that use immunity agreement. So anything that she's testified to, and I'll just mute it until it gets started, anything that she testified to can't be used against her. So and she testified a lot. So there will be some serious arguments about what evidence they had before she testified, what evidence they learned after she testified. So if they end up charging Wendy, which everybody kind of wants to see, it's going to be a little more tricky. But that would be a very, very high interest trial right there, Wendy Adelson. As much as we already had all the players in this trial already tried, almost all of them. We had Sigfredo Garcia, we had Luis Rivera, we had Katie Magbanua, then we had Charlie Adelson, and now Donna Adelson. Who knows? Maybe Donna's husband, forgot his name right now. Maybe he'll get charged. And then Wendy. I mean, is Wendy going to be the only one to escape? To live off the rest of her life not behind bars because of this whole story? We will see. Sidebars and side eyes, Broco. Oh, looks like we're getting started. So I'm sorry for everybody not saying hello, but we got to get started.
Morning, Judge.
I love Judge Everett. I love him. Debbie Blair says that several sources say the plea agreement was not true. I told you, I would find that very, very hard to believe. Very hard to believe that there's any sort of offer like that. Doesn't make sense.
Here this morning in State versus Donna Adelson, 2023 CF 3226 for the final pretrial hearing this morning. We're going to address all of the outstanding motions and also some matters pertaining to the trial, which is still scheduled for the selection of the jury starting on August 19th. The parties can make their appearances for the record.
Georgia Kappelman for the state.
Jackie Fulton for Mrs. Adelson.
Joshua Zellman for Mrs. Adelson.
I believe we have several defense motions to address. Ms. Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
Right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage. Mr. Zellman.
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in the motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance, they're not material in any way to this case. And so we're asking that aside from a very limited number of items that the state can establish has relevance, and it's not barred by hearsay, we're asking the court exclude that file.
Ms. Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right, as to the items that deal with, as identified in,
So this is the motion in limine where the defense filed that the divorce, all the divorce proceedings and the file that was in the court with Wendy and Dan Markel. So the defense wants all that stuff out. They don't want all that messy divorce coming into this murder trial, as you can imagine, because that's creates a very strong motive why perhaps they would want to kill Dan Markel. So this is the defense's motion limiting to keep it out. And we do know that portions of them have already been admitted in the previous trials. So now the judge turned to Georgia Kappelman and said, okay, well, which parts of that file do you want in? And she says, well, the entirety. We want the entire file admitted into evidence. And we think it's all relevant.
paragraph 7 of the motion. What exactly would be the relevance first? And what is your argument as to hearsay?
The relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
All right. Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markel, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's the way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive that.
All right. As to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
I mean, there are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. if there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means that are permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
All right, let's move on to the motion of limine concerning the testimony of.
Okay, we are going to switch this to Court TV.
Very involved in the pleadings. She was set the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
All right. Mr. Zellman, as to your client's emails to her daughter as this litigation is going on, are these contested in any way?
With respect to the initial dissolution proceeding,
So this is a little behind. This is on Court TV because I think the sound was a little bit better on Court TV. So that's why we switched to that. And they're just going over some of the arguments that we just heard. So we'll try to speed this up a little bit and get to the end where we were holding anyway. So basically they're arguing about the divorce file. The defense makes some good points about, how are you supposed to know which documents, which pleadings Donna Adelson saw and therefore responded or wrote about in some emails. So the judge did say that they're allowed to use the divorce file to show the volume of it, how big it was, because it was very litigious. There was a lot going on. It was very messy, to say the least. And they were filing things all the time, and it was very messy. So that could be cause for motive, the effect on Donna, et cetera, et cetera. But when it comes to specific pleadings, that's where they're talking, okay, so what about this specific pleading, that specific pleading? And basically it could be used to impeach. It can be used for other things. So this is really technical evidence stuff.
no. However, in reviewing the emails, the post-dissolution matters emails show that did not happen. So they can't go to show my client's motive if she didn't receive that.
Well, as to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive and intent, those are admissible. However, Ms. Kettleman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
There are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us will know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means that are permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
Okay, well, it looks like the sound is both the same by Court TV and Law and Crime, but nothing we can do on our
Let's move
side.
on to the motion of limine concerning the testimony of Sarah Youssef. Mr. Zellman.
Again, Your Honor, we We stand on the motion.
Ms. Kaplan, response.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
Well, then I assume you are going to leave Ms. Youssef available as a rebuttal witness if necessary.
Yes?
If the witness is not going to be called, essentially moves the issue. On that point, Mr. Zellman, the state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Youssef still is able to testify in that capacity. Right, the next motion in limine concerning the testimony of Stephen Webster. Does the defense have any argument that has not already been made through the pleading?
No, Your Honor.
Ms. Kaplan, response.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
Right, concerning the testimony of Mr. Webster, Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case. And also, he may testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to. Is any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markell. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception that I'm aware of under the hearsay rule.
Statements made by the deceased to Mr. Webster. Ms. Kaplan, do you have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markell to his attorney and offer my theory of admissibility prior to asking the question if I decide to do that in this trial. I don't think I plan to do that, so it's hard for me to address what that theory might be now.
Well, again, as a general principle of evidence.
Okay, so just to understand this, Mr. Webster that they're referring to is the lawyer who represented Dan Markell in the divorce and custody battle. Okay, so he was his family lawyer, Dan Markell, and he obviously had certain communications with Dan Markell about the relationship, probably about how contentious it was and the divorce and everything like that and the kids. So he may have had some testimony to talk, to give and talk about what Dan Markell told him. So this is what they're talking about, is that the defense is, well, that's hearsay. To have the decedent's statements brought in through his attorney is not proper unless there's some sort of exception to the hearsay rule. we can't have those statements come in. So whether Dan Markel felt, whether he said to his lawyer that it's just really bad and the relationship is bad and other things like that, it's all hearsay. And Georgia Cotman was like, yeah, I understand that it could be hearsay. I don't know what my theory was getting it in previous trials. If it does come up and I have an idea, then, I'd like to preserve and not just don't just deny it outright now. It could be there's a reason that I'll have to bring it up, and then we'll approach sidebar before. So that's what's going on with Mr. Webster.
Hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is granted as to Mr. Webster offering any opinions for which he is not qualified to give. The court will reserve ruling on the issue of any statements that he may testify to by the deceased if the state, again, will have to present an actual exception to hearsay in which the matter can be placed before the jury. The remaining motion in limine concerning the Latin Kings.
Latin Kings.
Mr. Zelman.
Yes, Your Honor. This goes in part to the theory of the defense and why Mrs. Adelson.
So this was the motion in limine on the Latin Kings. The Latin Kings was the gang that Luis Rivera and Secreto Garcia were part of. And the defense, I believe, made an argument that I'm not sure which way this cuts, but somebody did not want Latin Kings to be brought up as part of who Luis Rivera is, because Luis Rivera is a cooperating witness with the state. So he's going to testify in this trial and say that everything was all set up by Donna and yada, yada. But the question is, what about to bring up the fact that he was involved or he was a member of this gang, the Latin Kings? So that's what this motion in limine is about.
Acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation paid through her testimony for that, but if the court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There will only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly Special Agent, I believe it's Jimenez.
Now, in the last trial, he outright testified that he was, I guess, at least pretending or trying to influence your client as a member of the Latin Kings gang.
Yes, sir.
All right. To that end, Ms. Copperman, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting character of Mr. Rivera specifically in a negative light, the court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may present this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far as any cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markel. Now, with regard to undercover or the former undercover agent, this is where I believe the analysis begins to diverge on this topic. He specifically approached the defendant as a Latin King member, correct?
No, sir. My recollection is, I know that was his testimony, but I would instruct him not to say Latin King in future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. don't know how well he did, because Adelson didn't seem to think he did very well. But that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. I think the idea was just, you're an associate of this killer who is a gang member.
Any response on that topic, Mr. Zeldin?
Just looking at his previous testimony. My role, I'll quote from page 1067 of the trial transcript of Mr. Charlie Adelson's case. Starting at line 20, question, can you explain what that operation was? Answer, my role in that operation, I was portraying a Latin King gang member when I was instructed to conduct the walk. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member the person you approached? I did not. Okay. So you're just, that's the role. That was my role. You're a character. That is correct. That is his testimony. And yeah, I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous hearing last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
Even with that being said, this ultimately goes to your client's state of mind, who is going to establish how she knows the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
Well, as to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he is portraying a member of a specific gang as a part of his operation. Depending on what the answer is, we will revisit the issue of whether the name Latin Kings needs to be specifically uttered. As to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings, as it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had, or the fact that he had, or his role while he was recruited in this case, that certainly is right for cross-examination and may be inquired into. But as to him being a specific Latin King, that is where the line is going to be drawn. Do we need clarification of this ruling?
Just one here.
Not from the state judge.
So the concern we have, Your Honor, is that Mrs. Adelson, part of her state of mind, her level of fear, is that it's not just that she learned he was Latin King, but that he was the leader of one of the branches of the Latin Kings in South Florida. That heightened her fear. And of course, she will testify to that.
I cannot make her testify. If she is committed to do so as a part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about the state of mind from a witness that either has not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under defense subpoena. We would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine. Mr. Rivera, as I recall, never had any direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be, once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well. Mr. Rivera will remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages. Which witnesses is the defense referring to concerning this motion?
Your Honor, I think it goes really to retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about code language. Code language is treated different. What we're talking about is the emails, the recorded phone calls, and text messages, other than coded language. What we're asking the court, because it has come out so frequently, that the court prohibit the state and, what's good for the goose is good for the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Coleman, response?
I agree, that would not be admissible.
The motion in the limine is granted as previously raised in the argument on this matter. Any matters that would go to a code in which
Okay, so this has to do with the codes that they were using in the emails, like TV, like when they use different codes like that, what did they really mean? Basically, the defense is saying, well, they should not, witnesses should not be able to give their opinion unless they're an expert on deciphering codes. So even though it may be obvious to an average person, but still it's considered opinion. And therefore you can't go and give an opinion about what this code meant when you were talking about TVs or the like.
a witness could lay a proper foundation on this issue. Certainly, they may testify as to that point, but any general opinion as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness. Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Here we go. Vietnam.
Your Honor, I know that the court previously ruled on this issue that allowed the state to use this information in the argument. The new information, as I've laid out in paragraphs 4, 5, 6, and 7, I stand on the motion. Those additional pieces of information had not previously been provided to the court, and I think that it's significant because it goes to her state of mind for making the travel plans and for going to the airport and for stepping on the job.
From recalling prior counsel's argument correctly, Mr. Rashbaum did raise the fact that there was no legal process, subpoena, or warrant for your client, correct?
I believe that's correct.
So, response, Ms. Coleman?
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion. That ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as a trier of fact, is going to decide without significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and rule on as to the phone calls and other evidence that also will be presented to the jury as well. They will make up their mind.
Thank you, sir.
Well, no surprise there. I told you.
believe that covers the defense motions. And Ms. Coleman, you stated that the state did not have an additional motion remedies that have been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one also filed on July 21st concerning the opinion testimony of Jason Newland and Patrick Sanford.
Yes. Go ahead as to that motion.
I'm sorry, Your Honor. I'll stand on the motion.
Ms. Coleman, response.
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Coleman, even though it might be inquired into in deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course, there is no reason to elicit it at deposition, and it could never be admissible at a trial. So we're just wasting paper and time.
Ooh.
No objection.
The state is conceding the issue. The motion is
Yeah.
granted as to any opinions that would be offered by either investigator Newland or special agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief.
Who likes to see a spicy Georgia compliment? Usually she's very calm, measured. Got to see a little spice there.
I don't really see a context in which this might come around either in rebuttal or as far as impeachment, but again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, I'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19. We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, or prospective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday, essentially we will have the pre-screen of jurors on the issue of pretrial publicity, similar to what we did in the last trial. The court will be asking these same questions, or substantially same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group voir dire, from there they will be given the date and time for which group voir dire will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screen process, anyone who has had an issue or either the court believes, the state believes, or the defense believes is not suitable to go to the group voir dire. From there, each party will have an opportunity to make their objections known as to that respective juror, and they'll be told to return or they will be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are. Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we will have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes.
Okay.
I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end.
So another interesting thing about this trial is that the jurors are not going to be able to speak to each other before they are screened. Understand that? So like when you get to the you report as a potential juror, you're sitting in basically a big room with a lot of other jurors or potential jurors that may be called on a case, or there's someone specifically for this case. Generally, you can speak to each other. You can talk. It's like, hey, what's going on? How's life? You ever heard anything about this case? So apparently there was some sort of issue that happened at the last trial about this. I don't remember what it was or if it was brought up in open court. But to avoid that, there's going to be extra bailiffs looking around, and no one's allowed to talk to each other. When you come, you have to keep to your own devices. So you can watch Brother Counsel, but you probably shouldn't. As it relates to Donna Adelson, you can watch Brother Counsel and Karen Reed. But if you're summoned for this case, then you just have to either work on your phone, on your laptop, read a book. He said there's going to be reading materials if you want. So, but that's another thing about this case.
They are seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
Perfect, that's the state's request.
Judge, how many of the 300 are coming each day?
Broken up into groups of 50. So 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping altogether if we are able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to do 12 people.
How do you intend to handle proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
We've got a request for your honor.
But once we have our 12 jurors and 3 alternates, at that point, we will swear them. If we have enough time to actually move into opening on that same day at the selection, we'll do that so that way we can start to begin into witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7, so 6. I could see how it could run into the first part of the 7th day, Judge. I think 6 is a comfortable estimate.
Let me bring up my calendar.
So about a week for the prosecution's case.
Assuming that we have a jury by Friday the 22nd, we know that in place August 25th through September 7th as the state's case in chief. I think there's a holiday on September 1st, correct?
Yes, sir.
Is anyone volunteering to work on Labor Day?
Jackie is.
I mean, one other kind of unrelated to that side of the table.
Thanks.
It is a holiday for the workers of the world, but we cannot forget that we have a trial to finish. All right, 8:25 through 9:02, then we're estimating as the state's case in chief. How long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if Your Honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for the openings, only does the defense have a position concerning this.
We don't want to make openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer the opening to your case, you just don't want to open on the same day,
It's going to depend, Judge, on the ruling on the additional motion.
right? On that matter, again, depending on where we're at time-wise, I'll just instruct both parties to be prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, well, each party will be the captain of its own ship as to how you will captivate the jurors. Is either party expecting that opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Calvin?
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is comfortable range, Judge.
Right, as to the defense case, once we are finished with the state's case, how much time are you estimating?
Depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. So that would place us then around the week of September 8th. Concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members, both for the victim's family and for the defendant, to the parties anticipate making use of these rooms.
Yes, Your Honor.
Yes, sir.
Right. Please contact court administration. From there, you'll receive information as to how to access the rooms. and when they would be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
You intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday, we need to select a jury.
Okay. If we get a jury,
If we get a jury prior to that Friday, on say the 21st, really at that point, there's nothing preventing the testimony from getting started on the 22nd.
okay, so I'll be prepared to start testimony on the 22nd then, and my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th, is that right?
Okay, we just got to pause it here because you are in the right place if you think that you're in Brother Counsel University. We also refer to it as BCU. Don't worry, the t-shirts will be coming out soon, Brother Counsel University. Wear it proud. We'll get some bumper stickers also, maybe. But there's nothing I can do about the audio. There's just nothing I can do about it. I'm sorry. I was on Court TV, Law and Crime Network. It's just something going on today with the audio. Hopefully, trial was never like this, so they'll probably have it figured out by trial. But there's really nothing I can do with the audio. I can switch to Law and Crime, but they're about to wrap up the hearing anyway. But usually, yes, the audio is a lot better. But yeah, let's just finish up this hearing and then we can recap it.
Right?
Well, I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right, so we could potentially go through the week of the 8th.
If need be.
All right, I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not out.
We are losing a day because of September 1. But if need be, we can figure out logistically how to make this work for Saturday to continue working. I'm sure you all would like a break, but I'm here. Part of the time it matters, logistics that need to raise considering the trial.
Yeah, Judge, we're gonna have an issue regarding space. We're not all gonna fit here. We also don't want our computer screens facing cameras, and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large. Probably someone in the back row can see what I have on my computer, so we're gonna need to have, I understand we're blocked by this column,
Right.
but we're gonna need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is these microphones used to have the ability that you could touch it and it would turn off. My client is hard of hearing, so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And right, press and hold. You got to hold it down for it to continue to stay muted.
And the clicking, by the way, must be from the court reporter. She just must have her court reporter machine transcribing right next to a microphone. So they got to work this all out by the trial. Don't worry. The last few trials were very, very clear. So I'm sure they'll have it worked out by the trial.
We're going to ask if the court admin could put it back to the function where we can push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not going to be a record issue in our position, but it's certainly going to be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, in front of the jury, I definitely understand the concern that we're registering with this. We'll inquire if what can be done for the microphone on the table. If your client does need to write things down, so that way nothing's being given away, that might be the easiest way for that to be handled, but that requires the microphone. The seating set up in the gallery, I believe the first 2 rows behind the defense, those are not going to be available to any members of the media. As far as the font size of your computer, if you need to rearrange how you're seated at the table. So if you need a seat on the far left, or my right, your left, so that way your computer can face the ball and no one can see it. I don't really know what I can help you with as far as that font size beyond that.
Well, the problem is the end of the table it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
What I've tried a 3 co-defendant first degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this thing.
Right. Please make a request here in the court, and then we will figure out the best way to try to configure the tables. Ultimately, for what needs to come in with, I believe the state is going to try to, well, needs to bring in its equipment, audio equipment.
Yes, Your Honor.
All right. Because of that equipment and how it need to be set up, the tables and how they're configured can't interfere with that. We'll try to accommodate that as best as possible. This comment as to the audio visual needs of the state, other than what has been used before with the audio setup, is there anything that needs to be addressed?
No, sir, it'll be the same setup with the same company.
All right. Probably then.
Just want to address this comment for a moment. It says, if you are picked and it doesn't address it in your juror letter, call to the clerk and ask. They're very nice. We got a break, usually 2 hours, and lunch served in the jury 45 minutes in. Were you on the try? Were you on the other trial? Were you a juror?
We'll need to get started by the 15th in this room so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place before we actually get started on the 19th. All right. For the media presence that will be here as well, I believe it will be similar rules as it's been in the past. There will be one live video camera. There will be one still frame camera. Obviously, the bloggers and reporters, they are permitted to take notes as if they were print journalists. But the initial rows behind the state, Ms. Kappelman, I assume the victim's family is wishing to appear.
Yes, Your Honor.
They will receive priority seating with regard to how they're positioned in the gallery. After that, it will be free to the public and the press to seat in all areas that are available. Does either party need to be heard concerning those?
Your Honor, we're also in need space for our client's family and friends who are going to be coming to.
Oh, the client's family is showing up.
Request that they have similar priorities.
Isn't that nice? Because at Charlie's trial, Donna and her husband didn't show up. So I guess Donna's going to be having some family show up. That's nice.
That's what the 2 rows will be behind the defense. That will be available to family and friends. Again, similar to last trial, other than the video recording and still frame photography recording, beyond that, no cell phones are to be out recording any other matters or trying to take photos of the witnesses or the jurors. I believe similar in the last trial when Special Agent Jimenez testified, his face was not shown, obviously because of the nature of his past work. The court will just make the same ruling concerning that as well. His face is not to be shown, but of course the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of the jury, the faces of the respective jurors are not to be shown, their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated But ultimately, what we're talking about getting at is names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
There you are. One last thing, typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us, so that's another reason why we need that additional table. She also may have some additional people assisting her, and I'll make sure that they're identified to the bailiffs so that there are no issues there.
The members of the direct support staffs may sit on the benches that are behind the attorneys, or if we need to figure out a table configuration for them if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
There you are.
One other matter comes to mind if the attorneys can briefly approach.
Oh, one other matter. Okay, so we got the furniture picked out. We've got the music picked out. We got the clothing picked out. Oh, we can pretty much hear what's going on if you listen closely. Okay, now we can't hear. They heard me. I shouldn't have said anything. Lighting is set, as Poetic Justice just said. I mean, it looks like the trial is going to be about a week and a half, 2 weeks. So it's not going to be a very long trial like we had with Karen Reed, but it's going to be nice to get back with everybody and watch a trial. I actually have a trial coming up also in September. Ooh, I wonder if it's going to coincide. It might actually. Yeah, I've got a trial starting September 8th. So that might. No, we might finish before then. Yeah, we should finish before then, because what's going on is that they are scheduling jury selection supposed to start August 19th. All right. So August 19th is when they're going to start with the pre-screening. They're summoning 300 jurors. And I should stream my trial. I see what you guys are saying. Okay, we'll talk about that soon. But the jury selection is supposed to begin August 19th, right? So now they don't think it's going to take longer than 3 days. So that means that opening statements could potentially begin August 22nd, Friday. Potentially. And then they have the entire next week. Excuse me. So, and Georgia said it should take 5 to 7 days. So that should be August 25th. Let's say they begin opening statements August 25th. So that would be 1, 2, 3, 4. That would take us through the entire next week. Ending August 29th, the defense can start their case not December 1st, but September 1st, maybe September 2nd, after Labor Day. And then they should really have a verdict by the end of the week. Because, who's the defense calling already? Donna. She's going to be on the stand. Who else? So, yeah, we should have a verdict by September 5th. And then the good news is that September 8th is when my trial begins. So, if it goes to trial. But as of now, we're going to trial. So this might actually work perfectly for my schedule, my own trial schedule. Actually, this trial
will be in recess for today. The jury selection will start August 19th at 8:30 in the morning after the initial group of jurors has been qualified. From there, we will move into the pre-screening process as previously discussed. Have a good day, everyone.
Have a good day. Okay, so we're done with that. Let's remove this from the screen now. All right, so as we just went through, jurors know how to talk to each other. They're going to be calling 12 jurors and 3 alternates. Prosecution's going to go on for 5 to 7 days, and then the defense is going to put on a defense, perhaps. I mean, I don't know who else they're going to call besides Donna Adelson. They went through a bunch of different motions in limine. Nothing really too exciting. We'll break them down in the recap probably, but the most interesting one was the Vietnam one, and that was denied. So it goes to, there's really nothing new that was brought up. So my trial, unfortunately, is not going to be streamed. It's not really newsworthy, although I think it's newsworthy. It's a situation where we have, in my case, that we're, this is a client that I'm representing who was completely taken advantage of. Unfortunately, it's a civil case, and we're suing on behalf of her. And something that I uncovered during discovery on this case, I'm talking about my own case now. Something that I uncovered in the discovery of my case was that the defense, we had an evidentiary hearing because the defense was giving me very, how do we call this? Evasive answers in discovery. Okay, I would send a discovery, some interrogatories, some requests for production, and they were sending very evasive answers, which I knew something was up. I knew something was just, I've been doing this long enough to know that something was up. So I kept pushing on some of those issues. And eventually we came in front of the judge, and I said, Judge, we need to have an evidentiary hearing because there's something that they are trying to hide, and you're not allowed to do that. Okay, this is discovery, and you got to turn over what you know, what you don't know, and the documents that you have, and they're not turning something over, and I know it. So we had an evidentiary hearing, and in that evidentiary hearing, I got this guy in the stand from the other side, and the guy basically agreed. First, he perjured himself all over the place. If I'm going to call him in this case, and he's going to be shown to be a liar, and he is. But on top of that, he then acknowledged that he deleted his emails regarding this case. This is a case where I was asking him for emails. I was asking for different documents that could be attached to emails, whatever it was. And then in the evidentiary hearing, he said under oath that he deleted these emails because he always deletes emails. That's just like his normal practice. Anytime anybody tells you that their normal practice is to just delete emails, right away, it's a red flag. Now, we've heard about this in other cases where, people delete stuff, but specifically with this is a business. Okay. This is a business. This isn't just like a private cell phone conversation that you're having with a friend of yours or someone on your private cell phone. This is a business email address. And he was running multi-million-dollar businesses, this company. And to think that he would just routinely delete emails, that's a major red flag, because like if you have fiduciary duty, anything that's going on with any of the businesses that you have, that you're running, that you're controlling, and you're just deleting emails, that makes no sense. That makes absolutely no sense unless there's something really incriminating in those emails. And he acknowledged that he deletes emails. And not only does he delete, well, he claims, and I don't think it's true. I don't think this part is true because he perjured himself right and left. But he claims that not only did he delete the emails that are associated with my case, but he also deleted any emails that are all the time. He just deletes emails. Like, what type of person runs a multi-million-dollar business, and in his business email, he's deleting emails? Like, this you can't make this stuff up. So this is something that's going to be going on in that trial. Now, we'll see if this actually goes to trial. It's not even though it's a multi-million-dollar business, we're not suing for millions of dollars. We're suing for a lot less, but they're still playing very hard, and we're coming up to trial. And I'm not just going to take this sitting down. I mean, we are going to come out. So it's not going to be live streamed because, it's not newsworthy. Nobody cares about my cases at this point. But it's going to be an interesting trial. It should be a quick trial, actually, because I'm going to get this guy in the stand, and right away the jury's going to hate his guts. And that's all it's going to take, I think. But I don't even think the jury, after I'm done with this guy, the jury's not going to really care about my client and what the testimony of my client is anyway. I think they're just going to hate this guy so much that they're just going to find in my favor. They're just so evasive. They're so slimy. They're so arrogant. Everything that juries hate. And there's no way that these guys are going to be able to tone that down. That's just their nature. Like he's running these $1 million businesses. Like, he walks into the room and it starts to stink. Like that's the type of vibe that this guy gives. Like he's just so much better than everybody. So the jury's going to hate him, I think. And I think it's a very big mistake for them to go to trial. I mean, it's always a mistake when you're going to trial against me. That's what I think. But okay, they want to roll the dice on this one, I guess. So yeah, it's no problem with me sharing this publicly because I didn't say who the people are. I didn't say who's involved. I'm not saying anyone specific. But that is what's going on in this case. And we'll see. Okay, it's scheduled for September 8th. It's scheduled for September 8th. So we'll see if it actually ends up going. All right, guys. Well, anyway, so we're going to have to do the recap. There's something very exciting that I want to tell you about before I sign off, and that is that this Sunday has we have a very exciting show. Okay, so what's the show? Well, first of all, before we get to that, I want to give a thank you to Kim Neighbor, my neighbor Kim, 1580, for this super sticker. Appreciate that. And then also my good friend Root Bear Float, gifted 5 Brother Council memberships. I appreciate that. Now, what's going on this Sunday before you guys leave? No, it's not a members only recap. No, it's not a members only recap. Okay, no, it's going to be for everyone. Anybody who wants to come to my channel and check it out, we're going to recap. But what is happening this Sunday before I sign off is, you guys know I just got involved with this case, Mahendra Mikpatel. Okay, this is a case close to Florida. This is in Georgia. And the prosecution just dropped the case. Okay, so the prosecution just dropped the charges. They were charging him with some very serious charges: attempted kidnapping, simple assault, simple battery. And they dropped it because they have no case. If you looked at the surveillance footage, I did some videos on it, and probably you guys saw it. So what's very exciting is that I actually got in touch with the Mahendra Mikpatel, the person who was being charged with these charges that they were just dropped. So I got in touch with him, and we are doing a show together on Sunday. So this Sunday, I'm going to be doing a show with Mahendra Mikpatel. He's going to be coming on live. We're going to be talking about his case. The case is now gone, so we'll be able to talk about it freely and openly. And it's going to be I think it's going to be a very interesting conversation. So it's going to be, I think right now it's scheduled for 1:00 on Sunday for this live show. So it's I'm very excited about it. And, it gives you some confidence that actually when someone didn't commit a crime, that they're not going to be locked up and prosecuted. But the good part about it is that he's most likely going to be suing, and he should be suing. He sat in prison for like 47, 49 days for a crime that it's not, there's no probable cause in that crime. There's nothing. And he sat in jail for weeks. And when you're in jail with other people who they think that you are being charged with kidnapping children, right? Other people, other inmates don't appreciate those type of people. Like in jail, that's how this works. Like if you're in there because, you murdered a gang member or something, okay. I guess you're kind of accepted. But if you're in there for like these type of crimes with children, then the other inmates, I don't think, take kindly to you. And I'm going to ask him all these type of questions on Sunday. So it should be a very interesting, a very interesting, I should say, show on Sunday. So we're going to be having him on, Mr. Mick Patel, Mahendra Mikpatel, and that's going to be 1:00 on Sunday. So that's going to be it for now, guys. Thanks for joining us. We got the trial coming up. It looks like it's going to get underway maybe that Friday or the following Monday. So we do have a trial coming up where we can all hang out again. So that's going to be also nice for everybody. All right. Well, thank you very much for joining. We'll try to get the recap out to you shortly, and we'll see you next time. Have a great weekend, everybody.